Welcome both to those online and people in the room to the Centre for Deliberative Democracy and Global Governance seminar series. My name is Adele Webb. I'm a research fellow at the Centre, and it's my great pleasure to chair today's meeting. Before we begin, I want to acknowledge that the land on which I'm currently based is the land which has belonged for thousands of years to the Yurraguara and Turrbal people, the first people of what is now Brisbane. Many of you are at the University of Canberra, which is the land that has been stewarded by the Ngunnawal people for thousands of years. And together we acknowledge that these lands were not nobody's land, as I was taught as a child, but these lands always were somebody's land, always were, always will be Aboriginal land. And today, as every day, we acknowledge the laws, customs, and creation spirits of these traditional owners. Today's seminar topic of referendums will be, of course, one that's close to mind for many of us at present. Australians will vote in a referendum to amend the Constitution in less than 2 weeks. It will be the first in Australia since 1999. And I think we could all agree, despite the infrequency, the significance is quite unmatched in political terms. So today we're extremely lucky to be joined by our special guest, Professor Hui Kong. Professor Kong is a senior research fellow at the University of Texas at Austin's program on constitutional studies. He is, and I will give this a go, the inaugural holder of the Right Honourable Beverley McLaughlin PC UBC Professorship in Constitutional Law, which he assumed in 2018. Professor Kong researches and teaches in the areas of constitutional, administrative, municipal and comparative law, and constitutional and public law theory. Today's talk is titled Deliberative Democratic Constitutional Referendums. And I think even by that title, we're all super interested and very enthusiastic to hear from Hui. Before I hand over housekeeping, so Hui will speak to us for 30 minutes or so. We will have 30 minutes for Q&A. We'll take questions excuse me, from both online and in-person participants. So be ready to raise either your virtual hand or your in real life hand when the presentation concludes. Alternatively, if you're online and you want to put a question in the chat, that's also fine. So without further delay, I will pass over to our speaker. Welcome, Hui.
Thank you so much, Adele, for the kind invitation, for the kind introduction, and thank you to the Centre for this wonderful opportunity and the invitation to present. As I was saying earlier, I think the last time I was here was about a decade ago. So I'm hoping that the next time I come, it'll be a little less. There'll be a little bit less of a delay. I also want to acknowledge the Social Science and Humanities Research Council of Canada, which is funding the research that I'll be presenting here today. And the research that I'm working on, that I'm going to be talking about today, flows from a book. Part of it flows from a book that Ron and I wrote. I'm gesturing to Ron because he's in the room. I don't know if anyone else knows that. Ron's here. Ron Levy, that we wrote on deliberative peace referendums. And that was the use of referendums in a very sort of specific set of circumstances. And we developed a set of institutional design proposals and a set of normative arguments around a very specific use of referendums and a set of justifications for referendums in deliberative democratic terms. This argument, what I will be presenting today, builds on those arguments and is also a part of a larger project that Ron and I are working on populism and deliberative constitutionalism. And so I hope to, after my time in Canberra, to have a book proposal in hand. And perhaps the next time I'm in Canberra, I'll be able to talk about a book. Okay, so this is a presentation about constitutional theory and institutional design. And basically there are 3 parts. So the first will be an argument about a theory of constitutions and constitutional change. And there I'll make an argument that justifies both constitutions, or attempts to justify both constitutions and processes of constitutional change in deliberative democratic terms. And I'll respond to a powerful argument about that situates both of these things, constitutions and constitutional change, in what I will call populist terms. And so I understand populism is a highly contested topic. There's a lot of debate about what it means, but I'll pull out some specific strands that I think are shared among populists, varieties of populism, and show how this particular understanding, this deliberative democratic understanding of constitutions and constitutional change is juxtaposed to that. Second, I'll talk about referendums. And referendums have often been justified in populist terms. Populists make use of referendums. And so in this section of the presentation, I'll talk about a deliberative democratic justification for referendums and some deliberative democratic implications for how referendums should be designed. So with that background, with that setup, I will then move to a referendum held in Canada in 1995. So just this morning, I learned from Ron that he was leading the McGill University, which is in Montreal, students' march at the time of the referendum in 1995 on Quebec's secession. And so this is, I think, an interesting case study and for the general argument, theoretical argument, and for the institutional design implications of that argument. I hope in the Q&A I'll be able to, I'm not sure how much useful I will have to say, how much I say will be useful for the ongoing debate, but I think that the different constitutional experiences of jurisdictions that are similar in nature as Australia and Canada are, can maybe be helpful in the comparative discussion. So let me start with the theoretical, part one, the theory of the Constitution. So the initial question is, why do we think constitutions are legitimate? Is there a case to be made for the legitimacy of constitutions? Now, in constitutional literature, constitutional theory literature, there is a kind of debate about what constitutions are, what purposes they serve. And there's a good number of authors who kind of make an argument that, look, every political order has a descriptive constitution. That is, every political order has some means of distributing power, allocating authority, and regulating the relationship between those who hold power and the state, and ordinary citizens. And so under this approach to constitutions and constitutional theory, there's no inherent normative content to a constitution. Right? A constitution just is about the allocation of authority. And so an authoritarian, an absolute monarch, as soon as they have constituted institutions of power and distribution of authority, right, that is a constitution. So Ron and I, for some time now, have developed what we call a deliberative constitutionalist theory of constitutions. And this derives from Rawls. And the argument essentially that we make is that, well, we have to not only consider the fact of constitutions, we should think about why constitutions are legitimate, why they're justified to those who are subject to its authority. And so here we take a broadly Rawlsian approach, right? And generally we say that constitutions provide the kind of essentials, right? The constitutional essentials that can be justified to those who are subject to the authority of the Constitution, right? The general requirements of public reason. Yeah. So the terms of the Constitution, in order to be legitimate, must be reasonable and rationally defensible to those who are subject to it, to its authority. So that is a general picture, our general sort of theory of what makes a constitution legitimate. And it's juxtaposed, I think, against certain populist conceptions of constitutions. Right. And so I said at the outset that, of course, populism is a contested concept. I'd like to isolate out, I think, elements of populism that I think are more or less accepted by populists of a variety of stripes. And the first aspect is, I think the really important aspect is this dichotomy between the people and the elites. And so whether we're talking about Bernie Sanders, or we're talking about Trump, across the range of different varieties of populism, I think that there is this juxtaposition between the people and the elites, right? And there is a kind of suspicion of elites who govern in their narrow self-interest and not in the interests of the people as a whole. So I think that that covers a variety of populisms. Yeah. So translated into constitutional law, a version of this theory of populism evinces a kind of distrust for the institutions of representative governments, of elites, institutions that are that check the power of political actors. Yeah, and so there's a general kind of skepticism about things like judicial review. And so, what is now that's, I think, a kind of commonly accepted features of populism. Within the constitutional law context, within constitutional context, I think that there are versions of constitutional theory which understand the legitimacy of constitutions in terms of the will of the people, the will of an undifferentiated people. And constitutions are legitimate in this view because they express that will. Now, as a matter of contrast, then, between the deliberative constitutionalist conception of constitutions and this populist conception of constitutions is the importance of deliberation and reasoning. Yeah? So there is no requirement of public justification within this populist vision, right? As long as the Constitution expresses the will of the people, that is sufficient. Okay, so that is a general theory of constitutions, right? The legitimacy of constitutions in general, right? And as I say, in constitutional literature generally, there are people who would say that a populist conception of the Constitution, insofar as it creates the institutions of a constitutional order, that's all we need to know about whether something counts as a constitution. Now, I think there are implications of this conception of these contrasting conceptions of constitutions for how we understand constitutional change. Right? And so Ron and I, in the book that we co-authored with Ian O'Flynn on deliberative peace referendums, say that, look, the processes of changing constitutions should also partake of the general justification, the requirement of justification for constitutions, the substance of constitutions generally. Right? And that is, so we say that constitutional change, the processes of constitutional change, should also satisfy in some measure these requirements of reason. They should be fashioned in ways, the ways the Constitution can change should also be fashioned in ways that are justifiable to those who are subject to the changes in a Constitution. And so, to put it very, in concrete terms, if we have a referendum, right, and this sort of moves me into the second part of the paper, right, the second part of the presentation, the place of referendums within this debate about constitutional change. If referendums are a mechanism of constitutional change, right, one mechanism, not the only mechanism, how do we justify them? Right, and so in the deliberative constitutionalist conception of constitutional change and of referendums in the constitutional context, right, referendums have to satisfy these requirements of public reason. So we say that the means by which referendums are undertaken should be characterized by reciprocity of reasons. People should be exchanged reasons that are acceptable. Processes should facilitate that kind of reasoning. There should not be, the processes of referendums should not be subject to manipulation, should not be subject to the vagaries of differences in resources, right? Referendums, we say, should facilitate deliberation that reflects the requirements and satisfies the requirements, broadly speaking, of public reason. Now let's juxtapose that against the view of referendums of some populists. Right? Referendums, in this view, do not necessarily need to satisfy these requirements because referendums are not sites of deliberation. Right? They're means of expressing the general will of the people, and in certain varieties of populism, of the undifferentiated will of the people. Yeah, and so the fact that a referendum does not meet the requirements for deliberation and for public reason is not a reason to doubt their effectiveness or their legitimacy. Referendums are simply a means by which the will of the people is expressed. Now, so this is a kind of at a general level of justification. Sort of why do we think that referendums, and in particular constitutional referendums, are justified, and how can they be justified? Right? This also comes down into the level of institutional design. Right? This is the argument about public reasoning and about deliberative justifications for constitutions, for processes of constitutional change, flow into our arguments about constitutional referendums. So what does this mean? So we say that, and we are not alone in making these arguments. Stephen Tierney, for instance, has made similar kinds of arguments, right? So how should we fashion things like the question setting for a referendum? How should we structure the processes by which referendum campaigns are, by which they're run, right? And do we have to think about the capacity of people, right? When is it appropriate to bring a constitutional question to the people, right? Because it's consistent with our general theory of deliberative constitutionalism, right? We think that a referendum, right, is a useful instrument, is an important mechanism of constitutional change when it calls upon the people to express themselves and to deliberate on matters that they are competent to deliberate about. Okay, so what does this mean concretely for matters of institutional design? So first, we say that on matters on the setting of the constitutional question, right, there should, we say, be kinds of mechanisms to ensure that there is broad public input and that the questions are of the kind that that reflect this kind of deliberative ethos. Yeah. And so there is, even among deliberative Democrats, a kind of, or as we would say, among deliberative Democrats, there is a kind of suspicion about referendums. But there's a suspicion that referendums which claim to call upon the people to deliberate and express a conformed view, right, are simply manipulated by elites. Right? So elites manipulate referendums both to set questions that are meant to advance the interests of those elites, right? And they set processes that allow elites to dominate. And so what appears to be an attempt to have widespread deliberation within a society is just an instrument for the delivery of elite preferences. Right? That's the general criticism of referendums, often advanced by deliberative Democrats, including, for instance, Simone Chambers. Yeah. So the design of referendums, in order to satisfy the requirements of legitimacy, should counter these concerns about referendums expressed by deliberative Democrats themselves. And so how can we do this? Well, there are a variety of ways of doing it. One is to say, look, when we set the referendum question, right, it is not within the exclusive purview of a government that might want to seek electoral advantage, pursue its narrow self-interest. Right? We would want a question that's set with a kind of deliberative spirit, right? That is setting a question that reflects the public reasoning requirements of a constitution. And so we say that one way of doing this is through something like a citizens' assembly, right? So we could have a citizens' assembly and we could have guided deliberations about what kind of question we would want to ask. Yeah. The running of a referendum campaign, we would want to have information that is accurate. So if we're going to have deliberations about constitutional matters, we want the information to be accurate, right? And so we don't want the referendum campaign to be flooded by inaccurate information. We would want, and so there are varieties of ways of doing it. You know, in a variety of jurisdictions, you have information booklets that are set out that reflect the views of the opposing sides, right, and that try to do their best to offer factually accurate information. Yeah. So in Portland, for example, when there are referendums, there is a citizen panel that creates an information package. Yeah. We would want referendums campaigns that are not dominate, that do not allow for the domination of those who have resources to shift and dominate the debate and drown out opposing voices. Right? So we say that the referendum campaigns are referendums around constitutional matters should reflect the requirements of public reasoning, and the process itself should counteract the possibility of distortion, right? So that a referendum campaign truly does respect the deliberative judgments of the people, right? And not merely instruments of elite manipulation. Now, there's a question that we raised in our previous book with them about what kinds of questions are appropriate for this kind of constitutional deliberation. Right? So there are really, really complicated technical questions of governance that your average person probably is not in the best position to engage in deliberation about. Yeah? And so we want to think about maybe a kind of deliberate division of labor between representatives and those who are able to make those kinds of judgments, come to those kinds of fashion those kinds of arrangements, and the ability of the general public to make decisions that can guide that those complex processes of institutional design. Okay, so that's referendums, right? So we have a general Rawlsian conception of constitutions and of constitutional change. That argument about constitutions and constitutional change flows into our justifications, our arguments about referendums, both as a matter of sort of justification, but also as a matter of how to design referendums. And just before I move on to the Quebec example, I think that we can say that, you know, if you're a populist, you may be more or less indifferent to these issues of institutional design. So we have populist leaders who use referendums, right, more or less to kind of elicit a view that kind of supports the view of the leader, right? Because the leader themselves are understood as expressions, as sort of manifestations of the general will of the people, right? And so if you are not concerned about deliberation, about referendums as a mechanism for deliberative and informed decision-making by the public, and you simply think of referendums as a mere instrument of delivery, of expression of the will of the people, right? Then you may be less concerned about these issues, these questions of institutional design. Okay, so now let's turn to the case study of the Quebec referendum in 1995. First, a little bit of background about the referendum in 1995. Quebec is a majority Francophone province in the Canadian Federation. Almost from the moments of the earliest moments of the creation of the Canadian Federation, there was a concern about the capacity of the Francophone population, which in the 18th century, 18th and 19th centuries, had certain characteristics, right, that were distinguishable from the English population, right? So there was a distinct culture. There was a distinct legal system, right? Like civil law versus a common law system. There was a difference in religion. The Anglophones were primarily Protestant, Catholics were primarily Francophone, right? And so from the earliest moments of conquest, when the English essentially won a war against the French, and Quebec became what would become Canada, became a English colony, there were debates about how to accommodate, how to protect the interests of the French-speaking population within an English colony, right? And so, just some examples. In the earliest moments after Royal Proclamation, so in the 18th century, 1763, there was a requirement of a loyalty oath, right, abjuring Catholic views of transubstantiation in order to hold public office, right? There was, contrary to the general practice of English settlement, an attempt to impose English law on all matters on the civil law system that had pre-existed the defeat of the French, right? There were questions about how, as the colony evolved, there were questions about how to ensure that the Quebec, the Francophones would have representation and their interests met within the colonial government. So in 1840, there was famously a proposal. There was a constitutional structure that flowed from a report from Lord Durham. And Lord Durham, his report argued for the assimilation of the Francophone population, right? Because of, well, for a variety of reasons, but the assimilation of the Francophone population and the diminution of their political and social power, right? So there was created a unified province of Canada, which had equal representation of Francophones of the two provinces, a majority Francophone and a majority Anglophone province, despite the fact that the Francophone population was much greater. And there was a kind of concerted effort to assimilate the Francophone population. In 1867, we have Confederation, and the Confederation bargain created a federal structure in which many issues that would affect the Quebec, the Francophone population, were given to the provinces. Right? So provinces were given jurisdiction over the kinds of matters that govern everyday life, right? Property and civil rights, the regulation of the sort of everyday aspects of political life within the provinces. The federal government was given jurisdiction over matters that were understood to be of nationwide significance. Yeah. And so one way in which we think of Confederation in Canada is the Federation is as a mechanism for protecting the interests of the Quebec, of the Francophone minority, through the province of Quebec. So between 1867 and the referendum in 1995, we have a history of this continuing attempt to ensure the continuing thriving of the Francophone population. And there were concerns throughout that history, right? So there were differences in economic levels of income between Francophones and Anglophones. There were differences in possibility of social mobility between Anglophones and Francophones, right? And by the 1960s, Quebec as a jurisdiction became a kind of vehicle for aspirations of the Francophone minority. And there was a creation of the welfare state and all these rich variety of sources, policy instruments to pursue the interests of the Francophone minority, which had by that time had become concentrated in the province of Quebec. So that is the backdrop. Right? And the referendum, there was a referendum in 1980 that failed. And then the referendum in 1995 followed from several attempts at constitutional change that would increase the powers of Quebec in order to meet the aspirations of the Francophone minority that was concentrated in the province of Quebec. That is the sort of general background history, right? And so the referendum of 1995, right, was a referendum against this backdrop, right? And so the referendum had a variety of features, which I suggest do not quite rise to the exigent requirements of our deliberative theory of referendums. Let me talk about a few. So first, there was a question of agenda setting. Who sets the question? And so in this case, it was a government, a government that was in favor of independence, in favor of secession. And as the process began, there was initial bill entered into the legislature. Initially, there was a kind of proposed, relatively straightforward question. Right? And the question was, are you in favor of Quebec's sovereignty as set out in this bill? Right? But over the course of the referendum campaign, it became clear that that question would not get a majority. Right? People were concerned about the economic uncertainty that would flow from a vote in favor of secession and vote in favor of sovereignty. So there was an adjustment. And by the time the bill was actually passed through the legislature, the bill for the referendum, the question was a question that was kind of a joint question about sovereignty and about a new economic arrangement between Quebec and the rest of Canada. And so the question read as follows. Do you agree that Quebec should become sovereign after having made a formal offer to Canada for a new economic and political partnership within the scope of the bill respecting the future of Quebec, that's the name of the bill, and of the agreement signed on June 12, 1995, which is an agreement among the sovereignty political parties, right? Not a referendum question that is not the model of clarity, yeah? And the bill itself sets out a complex set of political arrangements and negotiations and really a kind of structure for a new relationship between Canada and Quebec. So the referendum was waged on this question, a question set by government that was wanted to achieve sovereignty, that was concerned that the earlier clear question was not going to attract a majority, right? And eventually, by the time the referendum happened, right, the outcome was a difference on a population of about 4.5 million of 30,000 votes, right? The referendum campaign itself, to go back to our kind of features of a deliberative referendum, had, in addition to these problems of question setting, right, there were problems of quality of resources. So the federal forces were able to bring in resources from the federal level of government that were not subject to the funding restrictions that the referendum rules set, right? The information that was sent out to voters, right, was a copy of this bill, right, which the terms of which, the content of which were set by the government. There were commissions set that were meant to study all different aspects of the new sovereignty, conditions of sovereignty, right? Those were kind of shelved and not given very much publicity, particularly those that did not support the case for sovereignty. And so at the end of this process, we have a no vote on a very, very narrow margin. And so the question that I think that comes out of the Quebec referendum, right? Yeah, I'm coming to the conclusion, right? In the minute and 15 seconds I have left, is, how can we design referendums, constitutional referendums, in a way that is in a better way, in a way that meets the aspirations of a deliberative constitutional conception of referendums, right? And so the Quebec example, and I think that having spoken to John on the way in, right, suggests a variety of ways in which we can structure constitutional referendums in a way that it meets deliberative democratic aspirations. So John mentioned that there was a proposal for a citizen assembly, right? A citizens assembly, I think, could have been helpful in the creation of a referendum question. There are also questions about division of deliberative labor, right? Was it a great idea for the general population to vote on a complex bill that set out a complex structure, right? There's also questions about how to sideline, or not sideline, but how to ensure that the referendums are not simply an instrument of one side of a constitutional debate to pursue its objectives, right? So that's my presentation. That's the sort of part of the new book that Ron and I are working on, right? A deliberate defense of constitutions, constitutional change, referendums, and a specific case study that illustrates how a referendum, constitutional referendum, might fall short of deliberative democratic aspirations.